Hello, I'm Jason DeCruz with Morris, Manning & Martin, and I am trying to give you an update on House Bill 30, which is the new Georgia Restrictive Covenants Act. As you may have read or heard on the news, this act has been signed by the governor. So the question is, what does it mean to you, the business owner? What it means is really that the law in Georgia on restrictive covenants is going to change in 5 key areas. First, this law expressly permits restrictive covenants, including non-competes. That is a change from the past where Georgia courts have not been have not looked upon favorably upon restrictive covenants. Number 2 is it relaxes certain standards under existing law for drafting enforceable covenants. In other words, the legislature has given the drafter some wide discretion in the wording to use for non-competes, non-solicits, and non-recruits, and also non-disclosure of confidential information. The third thing that this new law is going to do is it's going to give the Georgia courts the ability to blue pencil or modify otherwise unenforceable agreements. And this is huge. This is really a sea change from what the current Georgia law is. Under current Georgia law, if the agreement was unenforceable, the court had no other option but to strike it down. Now the legislature has given the courts the ability to strike through portions of the covenant which are, in the court's mind, unenforceable in order to make the covenant now enforceable. The fifth and final thing that the law does is it establishes presumptively reasonable time limits for these covenants. For example, it says 2 years would be a presumptively reasonable time for a particular type of covenant. Now, this law does not replace existing law. It only applies to agreements which are signed after the governor signed House Bill 30. So any agreement signed before is still governed by existing law. Any agreement signed afterwards will now be governed by House Bill 30, the new Georgia Restrictive Covenants Act. The other thing about this is it does not apply to all employees. The legislature specifically limited it to higher level employees or employees with access to confidential information. And there's a long list of employees to whom this act will apply in the legislation. The last thing that business owners need to know is that this act does not only apply to employment agreements, but it also applies to agreements, other types of corporate agreements, such as distribution agreements, lessor-lessee agreements, partnership agreements, franchisee agreements, the sale of business documentation, and agreements between 2 or more employees. 2 or more employers. So those are the high-level changes. We would recommend that you look at your existing employment covenants agreements and your existing corporate documentation to determine whether those documents need to be changed to afford the company the greater protections which are offered by this Georgia Restrictive Covenants Act. Thank you.